So most of you weren't around for Casey, and so I want to give some context to when this case was decided. This case was decided directly in the middle uh, of a presidential race. It came out in 1992, coincides with the presidential campaign, and traditionally, during presidential campaign years, the Supreme Court doesn't take too many controversial hot button issues. But everyone watching this case and everyone forecasting this case realized that Roe v. Wade, the precedent in Roe v. Wade, was really on the line here. And the administration defends the state restrictions in this case. So the presidential administration, who is being challenged, actually defends the restriction in the case. And so it became a topic that was exceedingly salient at the time, and so that many observers were watching the case. Now, it's important to note that there is no opinion that carries a majority of the court in this case. Five justices agree on a few things, but there's no majority opinion, so to speak. Justice O'Connor's, Kennedy, and Souter write a plurality opinion, and they're joined by Justice Stevens and Justice Blackmun on a couple of points to form a majority outcome on a few things. But no opinion in its totality has an authoritative state over precedent here. One thing that is clear at the outcome of this case is that there are five justices who agree not to overturn Roe. And that's perhaps the largest takeaway from Planned Parenthood v. Casey, is that even in 1992, with a number of conservative appointments on the court since Roe v. Wade was decided, the court still defends, in a sharply divided decision, the fundamental rights underlying Roe. So what are the facts in this case? Well, Pennsylvania, like many states had at the time, passed a number of laws which limited the availability of an abortion. They didn't outlaw the practice entirely, but they sought to make it more difficult to obtain an abortion. Among the parts of the law in question, one required an informed consent prior to a 24-hour waiting period. Minors seeking to obtain the procedure had to have informed consent of at least one parent. Women whom were married had to notify their husband. And a number of restrictions were placed upon the facilities that were performing abortions as well. If any of these laws sound, I don't know, somewhat familiar to the modern day landscape of abortion, they should, because these are the type of restrictions that we're seeing being passed more and more often within states today, and the states are doing it for the same reason that the states did it in the early 90s, and that was because, and is because, looking at the Supreme Court in the early 1990s and looking at the Supreme Court now, conservative politicians see the likelihood that Roe can be overturned with the current court. So politicians in the state of Pennsylvania saw that there was a likelihood that the court would overturn Roe, just as a number of politicians in a number of states see that there's a likelihood that the current court sitting in 2021 will also overturn Roe. So in Planned Parenthood, the court upholds some of the restrictions, but not all. And it articulates a position in which it's very clear that the court is going to defend Roe v. Wade. In fact, in the first sentence of the opinion, the court sort of addresses this problem. They say that liberty finds no refuge in the jurisprudence of doubt, yet 19 years after our holding that the court protects a woman's right to terminate her pregnancy in its early stages, that definition of liberty is still questioned. So very clearly, the court is articulating the point that they're a little frustrated that they have to continually revisit this issue. So after considering the fundamental constitutional questions resolved by Roe, principles of institutional integrity and the rule of stare decisis, we conclude this: the essential holding of Roe v. Wade should be retained and once again reaffirmed. So very clearly in a statement that displeased many conservatives, the court seeks to defend the underlying premise, the underlying holding of Roe v. Wade. And it does so by defending the 14th Amendment due process clause, the substantive due process clause. It argues that, you know what, marriage is not written in the Bill of Rights either, but we recognize that right as fundamental, and that thus the court has declared unconstitutional any number of laws banning interracial marriage during substantive due process, and that substantive due process is very much a part of how the court operates. The very concept of the rule of law underlying our own Constitution requires continuity over time, and that a respect for precedent is by definition indispensable. The court looks at the findings of Roe, and it looks to see whether the central nature of Roe has been unworkable. And they acknowledge that there are problems with the Roe decision itself, but it has not in any sense proven unworkable. No evolution of legal principle has left Roe's doctrinal footing weaker than it was in 1973. No development of constitutional law since the cases has implicitly or explicitly left Roe behind as a mere survivor of an obsolete constitutional thinking. Thus, from a mere nature of stare decisis, a near nature of precedent, Roe must be upheld. So what particularly in question was struck down and was ultimately upheld in this case? Well, there were a number of things that Justice O'Connor, in her opinion, argues, and that is, again, coming back to this idea that the fundamental nature of the right must be protected, but the trimester framework is functionally unworkable. And so she argues that this unduly burdensome standard must be applied, and that's how she judges each of these laws going forward. She recognizes fully that a right exists, but there can be restrictions put upon this right. So if the state puts a significant obstacle in a path for a woman to seek an abortion, then that law has to be declared unconstitutional. So, for example, particularly in this case, neither informed consent nor a 24-hour waiting period provision were unconstitutional because both of those provisions still ultimately allowed access. They were simply checks in the way. For the same reason, parental consent was valid as long as there was an adequate judicial bypass, which means that if for some reason a minor in this case was pregnant and seeking their parents' approval for an abortion might be problematic for any number of factors, there has to be a judicial bypass that will allow the minor to act in their own best interest. But the one provision that was held unconstitutional was spousal notification. Justice O'Connor cites some social science demonstrating that anywhere from 1/5 to 1/3 of women are physically assaulted by their husbands at some point during their lives, and thus it would be absolutely unreasonable for the state to require spousal notification in terms of abortion when a number of the women who would be seeking this approval would be victims of abuse, and therefore that spousal notification provision was struck down as it was seen as an undue burden on a woman's right to access an abortion. Finally, the requirements for the facilities maintenance and upkeep were constitutional, all except for one, which required a woman obtain the consent, as I said. And so this plurality decision is sort of, it's really piecemeal. Justice Stevens also writes a concurrence in which he concurs in all of the decision, except he dissents about the 24-hour waiting period and the informed consent, saying that those should have been held invalid as well. Justice Blackmun concurs in part and dissents in part. He is the original author of Roe, and therefore he's kind of protective of that decision, and where this decision, Casey, sort of goes off the rails with Roe, he dissents, still defending the nature and really the textual nature of Roe v. Wade. The dissents, however, the main dissent was written by Chief Justice Rehnquist. The decision really doesn't beat around the bush. They say very clearly that the joint opinion, following its newly minted variation in stare decisis, retains the outer shell of Roe, but beats a wholesale retreat from the substance of that case. We believe that Roe was wrongly decided and that it can and should be overturned. They argue that even if there exists a substantive due process right for personal or privacy reasons, that right does not extend as far as an abortion. So they're willing to cede some ground that substantive due process rights such as marriage and procreation and even birth control probably exist, but there's no envisionment in their minds of where substantive due process now extends to the purposeful termination of a potential life. They would overturn Roe and find all of the restrictions that Pennsylvania passed to be valid. And they would further argue that this is mainly a political process. This process, the court should not be weighing in. And the courts really should stop. But here you have 4 individuals, including 2 of the original dissenters in the Roe case, articulating a position that could have very easily been the majority decision of the day, less for Justice O'Connor and her stewardship going forward of the court, inserting this unduly burdensome standard, though it isn't precedent from this case. Understand there is no real takeaway in terms of nationwide precedent from this case. But the court has signaled very clearly that the defense of Roe v. Wade is continued, and at least a plurality of the court is going to move forward with this unduly burdensome standard, as opposed to the trimester framework, which was central to the precedent in Roe v. Wade.